You're a lawyer?
Correct, I am a lawyer, I believe I filed a notice of appearance.
We don't have a record. Make sure you file one. I'll take your word for it, there's no objection, but we need to make sure I have a notice of appeal. So I thought this was two pro se cases.
Oh, I
I almost
apologize.
took it off the LA docket, but we didn't have time to do that, so welcome to the floor, Ray.
Well, Your Honor, this is gonna be my first time dealing with a fellow argument since law school in the 90s, so.
Oh, boy.
Yes.
Don't do
yes.
it like they teach you in law school.
Well, thankfully, it's so many years ago, I'm not really sure how
Yeah,
to teach
remember.
law school anymore.
You want 5 minutes for rebuttal, sir?
Yes, Your Honor, I would prefer 5 minutes for rebuttal at the
Okay.
end. Your Honors, it's important in this particular case to give the background of what's been going on with these particular parties for the last 7 years.
I don't want to cut you off, and you can do that if you want to, it's your time. Just give us the relevant stuff. This is a lawsuit, maybe it's based upon the award of damages in those other cases, but that's not subject to the appeal today.
Well, Your Honor, what I would like to point out about the background of these particular cases is that it's led us to this specific case we're dealing with here today. And I do think it's important to at least discuss the fact that these cases all began in 2014. And the key aspects of me raising these other cases and talking about it here as it's regarding this subject appeal is that unfortunately for the last 7 years, or most of that last 7 years, Mr. Day has been representing himself pro se. I was recently brought in June, I believe, to help out with these things. Mr. Day has been trying to assert a valid cause of action against Rosedale, who has been represented by Mr. Fleck from the inception, who is the attorney that is the appellee in this
The
particular.
lawsuit individually against Fleck is to quote fraud upon the court. That's what we're here upon, right?
Correct, Your Honor.
Don't confuse me with all that other stuff. I get confused easily. Not only am I hungry, I'm old. So let's stick to what I need to decide.
Okay. And Your Honor, the first thing that I would like to point out about fraud on the court in this particular cause of action, and these causes of action that were raised by Mr. Day is that he was trying to assert causes of action regarding what occurred during the course of these underlying cases. One of the things that occurred, which is the basis for this fraud upon the court claim that he was trying to assert, is that one of the previous cases was erroneously and unlawfully dismissed for collateral estoppel, even though the standards for collateral estoppel weren't applied and weren't adhered
Okay, so
to.
you're saying fraud on the court is an exception to filing a notice of appeal within 30 days.
What I'm saying, Your Honors, is that Mr. Day is falling on the mercy of the court now regarding the fact that he's been trying to assert a cause of action.
I believe for that argument all the time, but my hands are tied by the law. I don't think we can overturn a decision in a previous case that it's up to the appellate court in that case if an appeal was filed. And if it was filed, it's the law of the case. If it wasn't filed, it's the law of the case. So keep going, however you want to proceed with that comment.
Okay, thank you very much, Your Honor. Well, the one thing that I do want to point out about this particular specific case, and once more, I will, again, Mr. Day's due process rights and his rights as a pro se litigant weren't honored from a standpoint that
In those underlying cases?
in this one as well, Your Honor, from a standpoint that he was trying to assert a cause of action individually on his own behalf. He should have been given an opportunity to.
Who was this lawyer?
It was himself.
Okay, was that his choice? It's not a criminal case, he's not entitled to a lawyer if he doesn't want to go hire one. That's a personal preference of his own. You take your chances that you don't know the law, and a lot of lawyers know the law, a lot of lawyers don't, a lot of pro se litigants know the law, the opposite. So that's a tough pill for me to swallow, that he chose to represent himself and he didn't get the pound of justice he needed or deserved. He got something less, minus due process.
And I understand your position on that, Your Honor.
I think it's universal, it's not just me. I wish he was different, you know? I wish we had exception for pro se all civil cases, they just have a little more leniency and flexibility in their presentation and the manner and the rules of evidence, but they don't have greater rights per se than anyone else.
Well, what we're dealing with here, Your Honor, is these matters in this specific one being decided based upon legal technicalities. And I understand what Your Honor is saying and what the courts generally say, but in my experience in 22 years, and there's a University of Chicago Law Review article I have that talks about how pro se litigants should be given more latitude than a lawyer in these types of cases. What we're saying is that Mr. Day
It's
has not.
under the heading of pro se, it's not under the heading of due process. They still get more latitude on procedural matters, lack of knowledge of the law, things like, I agree with what you're saying, it's probably a great law review article. But I don't know if that's gonna save the day here in Florida today.
I understand that position, Your Honor.
That's just me, I could be wrong, I could be persuaded differently.
Well, counsel, we have the third amended complaint here. You know, we have a lawsuit against an attorney that seems to revolve around awards that were made in those other cases. And I think that's a problem that this court is, you know, having, and probably the trial court had as well, in terms of seeing where you could possibly get a cause of action in a new case involving those other cases that where the damages in this case, if any, would be the awards that were made in the other cases primarily.
And I understand what you're saying, Your Honor. Again, I'm here arguing that throughout this process, throughout all of the cases that Mr. Day was unfortunately handling on his own behalf. He did have a lawyer briefly, and that actually the lawyer that was handling that is partially what led to the collateral estoppel argument that has been continued on through all of these cases. That collateral estoppel argument includes a case that was not dismissed based upon a voluntary dismissal. It was dismissed based upon a motion that was made by Rosedale buying through their lawyer.
Well, so we're bringing in the Rosedale complaints. I mean, there's all kind of issue there, not paying money, type of refunds, whatever it was, separate case, and then Fleck files a motion for attorney, or the court gives attorney fees under 57-105, and that's really what we're talking about today.
And that
And
is
that's based on abuse of discretion standard, correct?
correct, Your Honor.
And if you got an untenable lawsuit that you can't possibly get relief on, what's the trial court to do? Is that abuse of discretion when they give out fees?
Well, I'm saying here that it was an abuse of discretion under 57-105 based upon the fact that 57-105 is applicable, and that's at A, whether a claim was filed not supported by the material facts necessary to establish the claim or defense, or would not be supported by the application of then existing law to those material facts. So it's an or, it's not an and. So here, there were material facts to support the claims that Jim Day was raising. And those facts were that the fraud on the court was committed by and through Rosedale's attorney, who Mr. Day sued regarding the collateral estoppel issue that was presented to the court improperly in one of the previous cases.
Normally, brought in the court, you use the rule of civil procedure to reopen that first case. Motion to vacate the judgment, whatever, and then there's certain time frames. You don't follow a new lawsuit. That's what happened in this case. I mean, I haven't seen this happen, so it's an interesting concept, but I don't think the law even allows that. So if I was a trial judge, I don't think this judge necessarily got it wrong. You want me to rule it, the matter of law, the judge abused the discretion.
Yes, Your Honor.
Okay.
And what we're looking to do is we're looking to remand this back to the trial court
Do
for
what?
further consideration regarding the case itself, giving him another opportunity to plead a case, and if not,
Okay.
another opportunity to plead a case that 57-105 damages weren't applicable to this particular matter based upon the
So you want
circumstances.
us to reverse the judgment and not just the attorney fees, everything.
We're looking for you to reverse everything and send it back, but at a minimum, we would also ask that the 57-105 fees be reversed, because 57-105 is not applicable. First, based upon the fact that we're dealing with a pro se litigant here who did have material facts necessary to establish a claim. It might not have been a viable claim.
Well, the
But there's
judgment contained the attorney fees, and that's part of that judgment.
Correct, Your Honor. But there's also additional attorney's fees that have occurred after the fact.
That's a separate, that hasn't come to us yet.
No, that has not come to
Okay,
you, Your Honor.
I got you.
So here, we're not dealing with a situation where 57-105 is applicable, because that is only when there isn't any material facts to establish a claim of defense. Mr. Day did demonstrate felonious intent that would show that there was at least some application of an existing law or some material facts. One of the other facts specifically at issue in this particular case, again, is whether the claim for fraud on the court rose to a level of frivolousness that is so high that it would warrant Mr. Day paying Mr. Fleck's attorney's fees and costs for representing himself here. And we also believe that the evidence presented in the various legal matters demonstrated that this money that's at issue, and as I was going to say in the beginning, Your Honor, this whole thing started
From
from,
other case, golf membership and.
Thank you, Your Honor.
Et cetera, et cetera.
yeah, and the 11,000 that was provided to Rosedale, the disagreement regarding that, and their failure to return that money. That is what the genesis of all of these particular matters are, and they all flow from one another. From a standpoint, there's a valid cause of action here that Mr. Day, just in trying to assert in the legal technicalities and the procedural issues that he kept running across, is what has led him to this position where a dispute over $11,000 has resulted in 30 motions.
Well,
fees and over.
there's a lot of people who work on the rules. That rules committee has people way smarter than me. They made the rules up. I didn't make the rules up. So,
No, I completely understand, Your Honor. And again, I'm here. Mr. Day,
$11 after the fact. You're in a tough spot. I get it.
and Mr. Day was doing the best that he could. He reminds me a lot of my father as a Vietnam era veteran. As a Marine, my father was an Army man. My father didn't graduate from college, and he still is giving me
The
legal
Marine's
advice.
trying to get your attention on something. You may want to just read it and say that you read it.
Due process. His
Okay,
due process constitutional rights were violated, Your Honor,
I got you.
throughout the decisions here and the decision in this specific case.
I don't want to interrupt you, but I want to check on your time just in case I ask too many questions. See, okay, I'm doing.
Oh, I'm sorry, we're at 12 minutes. He's
So you're
got,
2.5.
yeah, he's got, yeah,
Okay.
Okay.
got about 2 minutes. We're
Okay.
actually at 13.
You got about 2 to 3 minutes for rebuttal. I'll see.
Oh, no, he's got 2 more minutes before he gets into his. rebuttal
Oh,
time.
good. Okay.
Again, Your Honors, the Mr. Day's due process rights and his pro se litigant rights were violated here, which led to the result we're dealing with at this point in time, where 57-105 should not be appropriate. If it's dismissed, it's dismissed. We don't believe, Mr. Day doesn't believe that his case should have been dismissed, that he should have been given an opportunity to file something that would be a viable case. But even assuming that the case wasn't viable, it doesn't rise to the level of 57-105, thereby obligating Mr. Day to pay Mr. Fleck's attorney's fees for representing himself. Again, this matter is regarding $11,000, where Mr. Day has paid over $100,000 to date in attorney's fees that have gone directly to Rosedale's attorney, Mr. Fleck. At this point,
Mr. Fleck was a bargain at 10,000, 15,000, it sounds like.
about 100,000, Your Honor, over
Oh,
100,000.
Mr. Day is looking for your attention again.
Mr. Day is also upset that as part of the violation of his due process and pro se litigant rights, he was never able to conduct any discovery in any of these matters to try to prove his case. Everything was dismissed in the initial pleading stages, again, based upon legal technicalities and procedural errors that as a pro se litigant,
And
he should.
are you talking about just in this case or in the other cases?
I'm talking about this case and the other cases as well, Your Honor.
Okay,
And the reason, again, I understand the constraints. I just wanted to raise the court's attention that this isn't one single matter. This has been an ongoing dispute between these people, these parties for over 7 years.
Well, that's fair.
Yeah.
Thank you.
all right, you've got 5 minutes for rebuttal, sir.
Good afternoon, this is Attorney John Fleck. I'd like to quote from Judge Sniffen in his ruling from the granting of the attorney's fees on September 29th, 2021. And Judge Sniffen on page 19 of the transcript, it's page 154 of the records, said, I will also say for the record that to the extent that multiple 57.105 motions were served, I would find entitlement as did each and every one of those motions. To the extent that the court has discretion to allow attorney's fees under some other provisions, like an unfounded case, or if I had discretion to do that, I would exercise that. But I think it's unnecessary since Mr. Fleck is seeking fees under 57.105, and I'm granting him that relief. Judge, respectfully under the law, Mr. Day and his argument today is confined to the issues raised in his brief and the arguments made in his brief. This appellate court cannot go outside of those specific issues raised and those specific arguments in the brief in which Mr. Day did not actually contest any of Judge Sniffen's rulings nor make those the viable part. His entire brief centers on his disagreement with multiple court rulings and other cases, including, if you notice, a second DCA ruling against him several years ago in one of his multiple appeals, and also the challenging of multiple other appeal decisions rendered against him. So his argument in his brief centers around issues not before the court, not within this case, and this court lacks jurisdiction to consider any of those arguments whatsoever.
Well, counsel,
Yes, sir.
Not some, I withdraw.
at least some of the argument in the brief centered around the order granting entitlement, and certainly the order granting entitlement was not final until the amount was ordered.
And Judge, do not confuse Mr. Day's arguments as to granting entitlement. Most of that argument centered granting entitlement as to other cases. If you notice, he talks about substantial findings where they're talking about in the lower, one of the lower small claims course, in which the judge found that Mr. Day's allegations of civil theft against the defendants was unfounded. Do not look at those arguments as necessarily applicable to him in this particular case, because he just supposes all those different arguments in other cases into this brief. If you look at the specific findings of the lower court, there's nothing that challenges the lower court in this particular case, saying that the lower court judge abused his discretion in finding entitlement to 57.105 attorney's fees, nor did he cite any specific facts in the brief finding why the lower court judge abused his discretion and didn't have the basis to do that. That's why I read the transcript from Judge Sniffen saying he would find a legal basis as to each and every one of the 57.105 motions that were filed, and Mr. Day could not cite any law nor any particular facts to contradict Judge Sniffen's abuse of discretion, and that was his discretion to do that. This court would have to find a specific fact and a specific law that would assert that Mr. Day had a valid claim. Judge Sniffen specifically found that Mr. Day had no valid claim from the very beginning of the case, no potential for a claim, and that he was very exact in his order in granting entitlement to attorney's fees. So, Your Honor, respectfully, this is not a case based upon a motion, as Mr. Day put in his brief, he's been litigating multiple cases for 7 years, multiple appeals for 7 years. This is not a person who is one who's just coming before the court on the first time. He has recognized that the lower courts, the intermediate appellate courts, and the second DCA have ruled against him in multiple cases, have cited and sanctioned him with awards of attorney's fees and costs in an attempt to stop him from doing exactly what he does in this case. He files his case, he litigates the case, and when we talk about interruption of justice, the very fact that Mr. Day is able to continue to file lawsuits both against the parties and their attorney, that has a chilling effect upon people such as myself, sole practitioners who have to defend themselves, who are unable to represent members of society who need an attorney, except I'm standing here arguing before the appellate court rather than representing members of society who do this. This case is the exact example of a chilling effect upon sole practitioners.
Well, one question, and I don't want to interrupt you, but in looking at the record, and correct me if I'm wrong, the appellant did not request oral argument. You requested the oral argument in this.
That is
case,
true.
did you not? Was there something that usually when oral argument is requested, you see something that can't be decided on the briefs? Was there something about this case?
Well, the thing
Since
that I
the
wanted to
appellant
point out-
did not request it.
You, correct. And one of the things that I requested oral argument for was the very fact that the entire case from the very beginning to the very end has a chilling effect upon attorneys representing defendants when there's the ability to sue the attorney who's representing. We're not talking about a case where he's saying that I injured him, that I said something wrong about him. And if you notice in his appellate brief and in his transcript, he says that the lower court judges conspired with me and that they were part and parcel of the fraud upon the courts. And when litigants are able to file briefs, file pleadings, file lawsuits in which they not only criticize an attorney such as me saying I committed fraud, but when they say I'm friends with the local judges and the local judges are part of the fraud and that they rule just because they're my friend, it brings disrepute upon the whole legal system. Meaning that's why the public has a view of the legal system that it does, because we have litigants who just are able to go out into public, go out into the Rosedale Homeowners Association and say, oh, Fleck is friends with all the judges and they rule.
You go beyond the answer. I think the answer was you felt it necessary to request oral argument.
Correct.
And generally, if there's an attorney requesting, if it's pro se, that we start out putting on the OA docket. I told your opponent, I almost took it off, but I found out too late that this was really two pro se litigants. But since an attorney showed up, I was relieved that now there's attorney versus attorney. It's so to speak, a fair fight as far as legal training goes. But I think, you answered the question, you proved your point, and I understand all that.
Thank you.
You've been around a long time, there's no doubt about it, so. Your turn. I'm gonna ask you to spell your name, because as you were telling me your name, I didn't even write it down. Not that I'm doing
It's an absolute doozy, Your Honor. It's spelled F as in Frank, A as in Apple, N as in Nancy, T as in Tom, A as in Apple, U as in up, zebra identifies, ZZI.
I mean, I know the name, I've heard the name before. Okay, so you have a few minutes for rebuttal if you need to use it.
Your Honors, in this particular matter, the one thing that is not in dispute is that money was confiscated. Jim Day's money was confiscated at some point in time. It was $2,500 and then another $6,000.
In those other cases.
Correct, on those other cases, which then led to the case that we're dealing with here. He's never had his cases adjudicated on the merits. He's never had an opportunity, this is the first opportunity he's really had to at least have someone other than the trial court judge on some procedural matter actually hear his complaints and what he's been going through these last 7 years. He's adamant that his due process rights were violated, that he did not have an opportunity under the Constitution, which is the bedrock principles of our legal system, to have a fair and honest fight in an adjudication on the merits. He also tried to file motions to compel to get discovery and answers to discovery, which were frustrated at every single opportunity. As a matter of fact, in a hearing that was conducted on December 3rd, 2021, Mr. Day was able to ask the Hogan, who was the vice president of Rosedale, questions about whether or he tried to attempt to ask questions about whether Rosedale confiscated the money, to which there was an objection and the court sustained the objection. So Mr. Day was never able to get an answer to that question. And one would assume that if the answer to that question was no, we didn't take it, that they would answer regardless of the objection from their attorney. Again, this is a situation, Your Honor, where the whole matter should be looked at, but at a minimum, 57-105 is not applicable in this particular case.
All right.
I mean,
Thank you, folks.
I'm sorry to do this at the very end. I hate it when people do this, but I'm gonna do it anyway. Just, I'm wondering, when you're looking at 57-105 and, you know, the standard about not supported by existing law, is that an objective or subjective standard? You know, given that someone's pro se, does that make a difference in terms of determining whether it's supported? They should know it's not supported by existing law.
I think that's somewhere where a pro se litigant should be given more latitude, as far as I've got these facts, and these facts from a standpoint of equity should give me this result. I don't know how to bake that cake to get it to that result. I'm doing everything I can. I'm struggling as much as I can. And yes, Mr. Day should have had a lawyer, and I understand what your Honor is saying, but we still have open access to the courts. And Mr. Day still should have been given his opportunity to have his matters decided on
Well,
the
counsel,
matter.
let me say, the pleadings that I read that were written by Mr. Day reflected, you know, quite a sophisticated understanding of at least a lot of law. So I mean, you know, I don't see him as a typical pro se defendant because of the pleadings, and you can look at them yourself and see that they were.
In my opinion, Mr. Day is the most dangerous type of pro se litigant who looks at things online and tries to interpret it the best he can. And that's why it looks like he's a little more educated than the standard pro se litigant, but he's still a pro se. He's not a lawyer. So regardless, he's still a pro se.
I just wanted to give him that compliment that he did.
Okay, well, thank you both. Now our docket is concluded for today.
All rise.
Thank you, sir.
Thank you. Travel safely.
Thank you very much.